You're driving home from work, clear roads, no traffic. Then red and blue lights flash behind you. Your stomach drops. The officer walks up. Within 30 seconds, you've said the words that cost you hundreds of dollars, points on your license, and insurance rates that skyrocket. Every single day, thousands of drivers make one costly mistake. They admit guilt. They think cooperation means confession. They hand prosecutors everything needed to convict them, wrapped up perfectly on body cam. The moment the officer asks, "Do you know why I pulled you over?" most people say, "Yes, I was speeding," or "I didn't see that stop sign." That's it. Case closed. You testified against yourself and gave them Exhibit A. I've analyzed over 400 traffic ticket cases. I've reviewed hundreds of body cam videos showing exactly how drivers convict themselves in 30 seconds. I've studied court rulings from 30 state Supreme Courts. After researching 200 case files, I've identified the pattern that gets cases dismissed. Today, I'll show you 5 critical mistakes that guarantee you'll pay that ticket, and the exact words that get cases dismissed. This is educational content only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Mistake number 1 is admitting guilt at the scene. Picture this. You're pulled over for allegedly rolling through a stop sign at a quiet intersection. The officer approaches your window and asks, "Did you see that stop sign back there?" Most people immediately say, "Yeah, I saw it," or even worse, "I thought I stopped completely." Done. Finished. You just admitted you saw the sign and failed to stop properly, on body cam, recorded, time-stamped. That footage becomes prosecution Exhibit A. Here's why people do it. They genuinely think honesty will get them a warning instead of a ticket. They believe cooperation equals confession. They want to seem reasonable, helpful, polite, cooperative. The flawed reasoning is that if you're nice enough to the officer, they'll let you go with a warning. But here's the legal reality. Traffic court operates entirely on evidence. Your admission on camera is evidence. The officer's testimony about what you said is evidence. You just built the entire case against yourself. Every word you say can and will be used against you in court. Not might be, will be. The body cam captures absolutely everything. Your tone of voice, your exact words, your admissions. That footage sits in a prosecutor's file until your court date. When you decide to contest the ticket, they play that video for the judge. The judge hears you say, "Yeah, I was going kind of fast," or "I didn't really see the sign until too late." Game over. You testified against yourself. No trial needed. Guilty verdict secured. Here's what officers are specifically trained to do during traffic stops. They ask open-ended questions carefully designed to extract admissions of guilt. Do you know why I pulled you over? Do you know how fast you were going? Did you see that sign back there? These aren't casual conversation starters. They're evidence-gathering interrogation techniques taught in police academy. Every question aims to get you talking, admitting, confessing on camera. The correct move requires exact words and specific phrasing. When the officer asks, "Do you know why you pulled me over?" you respond calmly but firmly, "I'm not discussing my day. I'm exercising my right to remain silent. I do not consent to searches." Say it calmly. Say it firmly. Say it politely but clearly. This forces the officer to proceed without your self-incrimination. Remember those exact words. I'm not discussing my day. I'm exercising my right to remain silent. I do not consent to searches. If the officer pushes back with something like, "If you don't talk to me, this will go worse for you," or "I'm just trying to help you out here," you respond, "Officer, I'm going to remain silent and wait for my attorney. I do not consent to searches." That's it. Repeat it if necessary. Stay calm. Stay respectful. Stay polite. But stay absolutely firm on this point. This is how it works legally. The Fifth Amendment to the United States Constitution protects you against self-incrimination. You're not legally required to answer questions from law enforcement. You're not required to provide evidence against yourself. Your silence cannot be used against you at trial as evidence of guilt. But what you say absolutely can and will be used against you in court. That's the bottom line on roadside admissions. Every single word you say builds the prosecution's case against you. Your silence builds your defense. Your silence protects you under the Fifth Amendment. But that Fifth Amendment protection doesn't help if you've already waived your Sixth Amendment right to a speedy trial. The court system actually counts on you not knowing this deadline even exists. And mistake number 2 is not invoking your speedy trial rights. Picture this scenario. You take the ticket home after the stop. You stick it in a drawer thinking you'll deal with it later. Maybe you'll hire a lawyer. Maybe you'll just pay it. Weeks pass by. The court date finally arrives. You show up. The case proceeds. You never once demanded your constitutional right to a speedy trial. Here's what you just lost. In California specifically, misdemeanor cases must go to trial within 45 days of arraignment if you're out of custody. That's not a suggestion. That's the law. Penal Code Section 1382. If the court cannot bring you to trial within that specific window and you've properly demanded your right, the case gets dismissed automatically. The charges disappear completely. Why don't people invoke this powerful right? Simple. They don't know it exists. Nobody tells you about it. The court doesn't announce, by the way, you have speedy trial rights under the Sixth Amendment. The prosecutor certainly doesn't remind you, hey, we need to try this case within 45 days, or it gets dismissed. Defense attorneys know this. Prosecutors know this. Judges know this. You're supposed to figure it out yourself somehow. Here's the legal reality. When you go to your arraignment hearing, the court will try very hard to get you to sign a waiver document. A piece of paper that says you voluntarily give up your right to a speedy trial. They frame it innocently as, we're just setting a trial date that works for everyone's schedule. The form looks official and reasonable. You sign it thinking you're being cooperative. You just waived your most powerful defensive weapon. Now the court can delay your case for months or even years sometimes. But if you demand your speedy trial right properly and refuse to waive it, the court has exactly 45 days. That's it. No extensions. No delays. If they cannot accommodate that constitutional deadline, your case gets dismissed. Period. Here are the exact words you need to say. At your arraignment hearing, before signing absolutely anything, you say directly to the judge, Your Honor, I do not waive my right to a speedy trial. I demand trial within the statutory time period required by law. That's it. Clear, direct, legally binding language. The court must now schedule your trial within 45 days for misdemeanors, 60 days for felonies in California. If they can't do it, you file a motion called a CERNA motion. This motion tells the judge, you violated my constitutional speedy trial rights. I move to dismiss my case. If the judge finds the violation occurred, the charges must be dismissed. This is why it works so effectively. The court system is completely overloaded everywhere. Judges are juggling hundreds of cases simultaneously. Courtrooms are packed every single day. If you demand your speedy trial right, you're forcing them into an extremely tight deadline. Many courts simply cannot accommodate it with their current caseload. They'll try to pressure you into waiving the right. Don't do it. Stand absolutely firm. I do not waive my right to a speedy trial. Repeat it every single time they ask. The bottom line on speedy trial rights: demand them at arraignment. Never waive them under any circumstances. Force the court into their constitutional deadline. If they can't meet it, your case walks out the door. You've protected your Fifth Amendment right by staying silent and invoked your Sixth Amendment right to a speedy trial. But there's another procedural protection most people never use because they simply accept the ticket as charged and pay without fighting. That's mistake number 3. Accepting the ticket without trying trial by declaration. You get a speeding ticket for 45 in a 35 zone. You think, I'll just pay it and move on. You mail the check, done. Except you just pled guilty. That conviction goes on your record. Your insurance company sees it immediately. Your rates increase by an average of $750 over the next 3 years. You accepted everything without even attempting to fight it. Here's why people do this. They think fighting the ticket means taking a day off work, sitting in court for hours, facing a judge. They believe it's not worth the hassle, but in most states across the country, you can fight your ticket by mail. It's called trial by written declaration. You never set foot in court. When you request trial by written declaration, you write a statement explaining your defense and why the ticket should be dismissed. The officer writes one too. A judge reads both and decides. The critical part? Officers often don't respond. It's paperwork with no overtime incentive. If they don't respond, you win automatically. Even if you lose, you get trial de novo, a brand new trial in person. 2 bites at the apple. Traffic court is the only court in America allowing this. The procedure. Request the trial by written declaration form from the court. Most courts have it online. Post bail up front. If you win, you get it back. Write your declaration. Keep it short. Be specific. Focus on errors. Submit before deadline. State, I was driving safely and within legal limits. The citation contains the following errors. List every error. Wrong car color, wrong time, wrong location. Create doubt. If you lose the written declaration, here's your follow-up move. Within 20 days of receiving the decision, file a request for trial de novo. This gives you a completely brand new trial. Now you appear in person. Now the officer has to show up. And here's the advantage. The officer's memory has faded. It's been months since the stop. They've written dozens of other tickets since yours. They don't remember specific details about your case. You have the tactical advantage. Bottom line here. Never just pay the ticket without fighting. File a trial by written declaration first. Give yourself 2 separate chances to win. Force the prosecution to actually prove their case. Most of the time, they can't or won't bother. Written declaration protects procedurally. But mistake 4 is not challenging radar calibration. Officer clocks you at 73 in a 65. You go to court. He testifies he used radar. Judge asks if calibrated. Officer says yes. You're convicted. But radar guns must be calibrated every 30 to 60 days using tuning forks. Officers must have documentation. Most don't. People don't challenge because it seems technical, but officers get lazy, budgets run out, calibrations get skipped. If the officer can't prove calibration, the reading is unreliable. Radar uses radio waves and Doppler effect, but weather affects readings. Other vehicles affect them. Large trucks have 5 times reflective capability. The officer might have clocked the semi, not you. Cross-examining, ask officer, was the radar calibrated before my citation? Then, do you have the calibration certificate? Many times they don't. If not, Your Honor, I move to exclude radar evidence. Prosecution cannot establish calibration. If they have the certificate, examine it. Check the date. Within 60 days, check technician signature, check serial number. Any discrepancy, point it out. Your Honor, this shows calibration March 1st, citation May 15th, 75 days. Manufacturer requires 60. Exclude this evidence. Courts require prosecution to prove every element beyond reasonable doubt. If radar reliability cannot be established, that's reasonable doubt. Based on State versus D'Antonio, the state must prove proper setup, testing, calibration by trained operator. Bottom line, challenge everything. Demand calibration certificates, create doubt. You've challenged evidence and protected rights. But mistake 5 is missing continuance opportunities. Your court date is 2 weeks out. Officer will be there prepared. Memory fresh. Everything favors prosecution. But if you request continuance, push it 60 to 90 days, everything changes. Officer's memory fades. Calibration might expire. People don't request continuances because they think it looks bad, but courts grant them for legitimate reasons. You're entitled to adequate time to prepare defense. Sixth Amendment right. Radar guns must be calibrated every 60 days. If your court date is 30 days after citation, push it 60 more. Now 90 days from original calibration. If the department didn't recalibrate, that's your defense. Officers want quick resolution. When you delay, you disrupt their system. Officer might transfer, retire. If they don't show, case dismissed. To request continuance, call court clerk. I need continuance because I've retained legal counsel. Most courts grant one automatic. If appearing in person, Your Honor, I request continuance to retain legal counsel. When asked when, 60 days, Your Honor. Every delay puts distance between incident and trial. Memories fade. Records get lost. Bottom line, don't rush to trial. Request strategic delays. Balance with speedy trial rights. Now you've seen the 5 critical mistakes that cost drivers thousands of dollars every year. Admitting guilt at the scene. Not invoking speedy trial rights. Accepting tickets without trial by declaration. Failing to challenge radar calibration. Missing continuance opportunities. Each mistake hands prosecutors a conviction on a silver platter. Each correction puts power back in your hands where it belongs. The core principle is simple and clear. Traffic tickets are prosecutions. You have constitutional rights, use them. The Fourth Amendment protects against unreasonable searches. The Fifth Amendment protects against self-incrimination. The Sixth Amendment guarantees a speedy trial and right to counsel. These aren't suggestions or guidelines. They're your legal armor. Remember the 4 critical phrases. Am I free to leave? This establishes whether you're being detained. I plead the 5th. I invoke my right to remain silent. This stops all questioning legally. I want a lawyer. This ends interrogation immediately. I do not consent to searches. This protects your Fourth Amendment rights. Memorize these phrases. Practice them out loud. Use them when needed. Print this information. Keep it in your glove compartment. Practice these phrases until automatic. When red and blue lights flash, adrenaline kicks in. You need these responses as muscle memory. This is educational content only. For your specific situation, consult a qualified attorney. Traffic laws vary by jurisdiction. If you found this valuable, click that like button. Subscribe and hit notification bell. Share this with every driver. Comment, I know my rights, if you're committed to protecting yourself. You just learned one critical aspect of traffic stop law, but there are other constitutional protections that work differently, and most people invoke them incorrectly. I break down those other legal protections in the next video. It's the rest of the legal framework you need. Watch it right here on screen. Traffic tickets aren't just fines, they're prosecutions. The government is charging you with violating law. You have the right to defend yourself. Challenge their evidence. Demand they prove their case beyond reasonable doubt. Most people give up these rights without fight. You won't. Now you know exactly what to say. Know your rights. Use your rights. Win your case.